Hello everyone, welcome again to another episode of The Letter of the Law through Bloomsbury Radio via Bloomsbury Institute London. This show is also going out on the London Legal Podcast as hosted by the law firm Hodge, Jones and Allen Solicitors. Now this is part 2 of an original conversation that we had previously about accidents at work, specifically personal injury law and how accidents at work is involved within that. And encompassing that conversation as well is the personal injury law clinic that is run through Bloomsbury Institute London. We're delighted then to welcome back Daniel Denton, partner at Hodge, Jones and Allen, as well as Jack Foran, paralegal at Hodge, Jones and Allen. And of course, one of our students, international law student, Faith Masha. So the previous episode, part 1 of accidents at work, which is such an in-depth topic that it's actually led to 2 podcasts, amazingly. But accidents at work essentially covered, we spoke about what accidents at work cover in the most general sense. We spoke about the PI Law Clinic itself, its aims, and how listeners could find out about making an inquiry, whether they wanted to get in touch to make an inquiry through the official bil.ac.uk website or via the telephone number itself. So in terms of accidents at work, what we spoke about at that time were the types of accident at work cases covered by that clinic, for example, manual handling tasks, unsafe systems at work, accidents working at height. We then moved on to some of the most common types of accidents at work that the lawyers at Hodge, Jones and Allen come across. For example, manual handling or slips and trips. Then the question was posed about if one suffers an accident at work, what steps should be taken immediately afterwards. And if an accident occurs while the worker is on someone else's site or premises, what steps should take place. So that takes us up to the present time in our conversation. And the first question I'm going to ask Daniel is, it's a straightforward question, but it's probably the most important one for our listeners and those who are thinking about making an inquiry. What is involved in making a personal injury claim with a legal representative such as yourself?
Yes, well, the first thing to note is that the burden of proof is on the claimant to actually prove their claim. So this means we not only have to prove that the other side did something wrong to cause the accident, or otherwise known as negligence, but also that the injuries that the client has suffered were also caused by the accident too. So the first part we have to consider is what we call liability. So by liability, I mean who is to blame for the accident. So the process is that the claimant's representative will send what's called a letter of claim to the insurance company of the defendant firm. So the letter of claim sets out the details of the accident, the reasons why we think that the defendant is to blame, the injuries that the client suffered, and also any documents that we might need to see should the defendant wish to dispute fault.
Great, thank you very much. And the defendant's insurers as well, what is the position with regards to that?
So the insurance company tend to investigate the accident themselves. When we send a letter of claim, what we tend to do is invite them also to fund some private rehabilitation treatment for the client under what we call the Rehabilitation Code 2015. So what, in essence, that involves is that we invite the insurance company to agree what's called a case manager. And the role of a case manager is to firstly go and visit the client at their home and prepare a report which is known as an immediate needs assessment report. Now what that report does is sets out all of a client's immediate treatment needs. So for example, that could be they might be waiting for a scan on the NHS, or for example they might be needing some physiotherapy or psychological treatment, or they might require a taxi account because they can't drive at the moment. And the case manager then prepares a report. They'll send it to both parties, so both the claimant's representative and the defendant's insurance company. Then the defendant's insurance company will decide whether or not they're prepared to fund that treatment privately. So the reason they would do that is the quicker the client can have access to treatment, the better chance they have of making a good or full recovery. And it's also got the added benefit as well of taking the pressure off the NHS in terms of the NHS having to deal with backlogs and treatment as well at the same time. Now the process is that the insurance company have to comply with what's called a pre-action protocol. So they have 3 months from the date of the date of the claim to actually decide whether or not to admit liability.
Great. Okay, so if you're just tuning in, we are on part 2 of our special on accidents at work, with discussing personal injury law. We've got with us in the booth today Daniel Denton, partner at Hodge Jones & Allen, and Jack Foran, paralegal, who I'm about to turn to. We've also really delighted to have one of Bloomsbury's international students, Faith Marshall, with us too, who's, I believe, going to be asking some questions at the end of this conversation. Before we get to that point, though, I just want to reiterate that if you are tuning in and you'd like to make an inquiry about an accident at work that's happened to you or perhaps to a loved one, then you can make an inquiry via the inquiry form on the Bloomsbury Institute London website. That's www.bil.ac.uk. In the search engine, just look for Personal Injury Law Clinic. You'll be directed to a page where you can complete an inquiry form to talk about what's happened to you or to another person if you are writing on their behalf. You can also phone to minimise that process and get straight to speaking with someone on 033 00 294 446, or if you do prefer email, it's bilradio, BILRADIO, all one word, at hja.net. So let's get back to accidents at work, and Jack, I'm going to turn to you now. So sometimes with accidents at work, of course, there are different situations and circumstances that take part, and sometimes people think, well, can it actually be the fault of the claimant or the fault of the person who got injured? So my question to you then is, can a claimant be held to be partly to blame from a legal standpoint for the accident?
Yeah, well, thanks, Sarah, and thank you to our listeners as well for bearing with us as part 2 was coming in. It just shows sort of the complexity of the issues that we're dealing with and how there's quite a lot to talk about, quite a lot that needs to be covered, and quite a lot that you need to sort of be going to seek legal advice about, especially when it comes to accidents at work. The short answer for, can a claimant be held partly to blame for the accident is yes, but that comes with a huge caveat that clients need to not worry too much about it. I think there's definitely a concern that some clients may have that if you say yes to that answer, that suddenly negates your entire claim. And some claimants will sort of step away and decide not to even claim at all because they think, oh, well, I was partly to blame there, or they may misinterpret it and think that they were fully to blame. But you've got to leave that to the legal experts to find the intricacies of what actually is the percentage split of the blame. It all comes into play when a claim is being handled. And even if it's sort of a percentage split of maybe 50-50, 70-30, the blame, even though you may think it's more on yourself, isn't always on yourself. Mm-hmm. And it's our job to find out what that split is. So in some cases, it may be the case that the claimant is partly to blame for the accident. And if that is the case, we will determine that percentage of the blame. It really depends on those allocations to be calculated. So once the percentage split is determined, that will contribute to how the compensation is split up. So if you are, say, found to be 50% contributory negligent to causing the accident, so for suffering the injuries that you've suffered, then a 50% cut will be applied to the compensation you're awarded. But it's certainly not a case, and you should not worry at all, that if, say, I'll go into examples in a little bit, but if you've done something you think perhaps contributed in some sense to what happened, that it completely takes away everything from your claim. And that, don't let that stop you. Seek legal advice first and let the experts say yes or no, or put you in that sort of right space of mind as to what kind of, if any, contributory negligence there will be for your case.
Okay. All right, so Jack, well, let's actually then bring everything to life. Let's talk about an example, as you alluded to. So if there has been contributory negligence of the type that you're talking about, can you, for our audience, just describe an example, whether it's an example that you just want based on your own casework or something you've dealt with previously, or just something that's hypothetical? Could you sort of bring it to life for our audience?
Yes, of course. I mean, I've got a couple of examples perhaps from the more accidents at work angle that we're approaching it from, but also a couple of which may be a bit more easier to understand from perhaps a road traffic accident perspective. But from accidents at work, think of it as you are, say, working in a construction company or working in a factory where you're using sort of motorised equipment, saws, etc., which are being used to sort of as part of the cut process for whatever work you're in. And say it's an unguarded machine, but you're putting your hand close to it and nearby to it. that's a situation where there's got to be an element of contributory negligence, because there's the element to say, yes, your employer has not followed safety regulations by not having that guard there to cover the chains, to cover the saw, to cover the motorised bit of equipment which could cause harm. But also you are there, you're an aware person who will have training. You've got to be very careful. You can't expect companies to take on full liability in some cases. There has to be an element that the claimant is partially responsible. Let that guide you, though, into the process, rather than saying, well then, I've done something silly here, because ultimately it might be the case that you haven't done something silly. You may just think that you have. So it's very important you seek legal advice in the first instance. Perhaps a more easier way to look at it is, say, in road traffic accidents, when two vehicles are involved. Unless you're the driver of a vehicle that's just been, say, struck in the rear or has had nothing to do with it, there will always, or quite frequently, be a percentage split that's applied to across the drivers, especially in cases where there isn't much evidence, i.e. there isn't door cam footage, there isn't dash cam footage or police evidence, and they kind of just have to say, well, look, in the absence of any evidence, we're going to have to come to an agreement here on perhaps 50-50 split, 70-30, based on witness statements that we have. But for accidents at work, it's definitely not always your fault, and it's definitely not always fully the employer's fault. There's an intricacy, and there's a level to finding the right percentage split there. But don't let that take your mind off bringing a claim in the first place, because it's very possible that in the moment you're not thinking about, well, that could be my fault, that could be their fault. Just bring the claim in the first place and see where it takes you. See what your legal experts are able to tell you about it, and they can point you in the right direction.
And Daniel, how about yourself? Couldn't you bring an example to life for our audience from your history?
Yes, so very recently I've received a new case where I have a client who acts as a machine operative, and he's only been with the company for 4 weeks, was in the process of being trained on this particular cutting machine. Mm-hmm. And what he's done is he's actually put his hand into a machine that wasn't guarded. And when doing that, he's suffered a very serious injury to his hand, as he's actually put his hand amongst the blade of the cutting machine. Now, on first glance, you might think, well, that's the client's fault for doing something that's silly, for want of better words. But we've got various arguments we can put to the defender, saying he shouldn't have been using that machinery until he had proper training. That training was up to date. And also that the machine should have been guarded. So in that situation, there's going to be an element of what we call contributory fault. So it's a matter of working out, usually using case law, other different examples of cases that have been where we've had judgments in the past, to work out what we think is a sensible level of blame apportioned to each party.
Sure.
It's preventative measures, really. It's looking at sort of two scenarios. What would have happened if the client had... what would happen if the client had, say, protective clothing on? So say they suffer an injury to their foot at work, and they weren't wearing perhaps their steel-toed capped boots, which would have kept their foot more safe from harm. If they were wearing those, perhaps the injury would have been lesser, or perhaps non-existent. But if you look at it from a lesser perspective, then the other side, the defendants, they will look at that and say, well, we get that he suffered this injury. We recognise that our negligence of our insured has caused this to happen. But if he were wearing that protective equipment, they wouldn't have suffered the level of injury that they have. And that's where those percentage deductions tend to come in. And a clear example there is also a cycling accident where you're not wearing your helmet. But think about the type of injury that you could suffer if you aren't wearing your helmet compared to if you are. Often the helmet prevents you from suffering far more severe brain injuries, head injuries, and cuts and bruises, etc. to the head.
Great. Thank you very much for describing those examples. We've been hearing from Jack Foran, Paralegal at Hodge Jones and Allen Solicitors, and Daniel Denton, Partner in the Personal Injury Department of Hodge Jones and Allen. This is part 2 of our conversation on accidents at work, as well as discussing the Personal Injury Clinic here at Bloomsbury Institute London. Now, if you are someone who has experienced an accident at work, or you know somebody who has, then do get in touch. The number is 03300294446. The email is bilradio@hja.net. And if you do want to speak to someone from the personal injury clinic straight away, then do so via an inquiry form, which is on the Bloomsbury Institute London website, bil.ac.uk. Just search for personal injury law clinic, and you can input your details there. Just a quick recap about the clinic, actually, Daniel, since we are speaking about that predominantly. Can you sum up very briefly what the clinic does and how a member of the local community can benefit from it?
Yes, so the idea of the clinic is to promote access to justice. So what we do is we offer any client, irrespective of their financial position, 30 minutes free legal advice. We normally have some Bloomsbury students accompanying the client to that meeting.
Mm-hmm.
So I would normally lead that meeting and ask various questions and give the appropriate advice to the client, and the Bloomsbury students would prepare a letter of advice that we normally send out within 21 days.
Okay.
So the university student would send the draft letter of advice to me to check. We would send that out to the client, thereby providing a free service to anybody who gets in contact with us. And if we think this is a case where potentially Hodge Jones and Allen could represent them, we would also advise them how the no-win, no-fee agreement would work as well. But obviously, there's always a caveat that the client can choose whichever firm of solicitors they wish to represent them.
Okay. So you spoke earlier about the position with regards to insurance companies and accidents at work, Daniel. So my question to you now is, if the insurance company only partly admits liability, what happens then?
So if we receive correspondence to that effect, the first step is to go back to the insurance company and ask them for any specific reasoning as to why they believe our client is partly to blame for the accident. This would also involve encouraging the insurance company to provide any documentation that they have in their possession that's relevant to that decision as well. So that may be documentation that's not necessarily favourable to the insurance company's claim, but we would insist on seeing that documentation already. We then face a situation where sometimes the insurance company will totally deny liability for the accident. In that case, there is sometimes a short delay in the case because, again, we would ask the insurance company for a full explanation as to why they think our client is fully to blame for the accident, and again carry out a full search and any relevant documentation. But then after we've received all of that information, we then have to risk assess the case again ourselves, just to make sure the case still has 51% prospects of success.
Okay, thank you so much, Daniel. Now, if someone is pursuing a claim with Hodge Jones and Allen Solicitors or any other firm, what type of documents are ordinarily requested, and what should the person who has suffered the accident need to get together for his or her legal representative?
Sure. So some of the documents we would normally request will be ones that are not necessarily held by the client, but the type of information we would need is the full name and address of the employer. There's ways we can check that by checking the client's pay slips, because it may not be immediately obvious. We'd also ask the client to provide us with their pay slips in due course, their contract of employment, and any other receipts they have to prove their losses in relation to the case. We also then make a formal request to the defendant for certain documents, so that could include documents such as the accident report form. It could be a CCTV footage that was taken at the time of the accident. It could be what we call a riddle report, and that particular report is a report to the Health and Safety Executive, which employers are required by law to actually send to the Health and Safety Executive if the employee has been off work for at least 10 days.
Okay.
We'd ask for any first aider report if our client was attended to by a first aider, and any witness statements they may have taken whilst investigating the accident, including an investigation report. And finally, we'd also ask for any meeting minutes, if they've discussed any health and safety meeting afterwards, this actual incident.
Okay.
Clients providing as much information at the early stage really expedites the claim. It expedites the claim for the client. And it's just so important because lots of requests that we have to make, if the client can get that information from the early stage themselves because they're entitled to it, it saves time on the end of the solicitors having to do quite lengthy and sometimes delay-based third-party requests from various different providers. Whereas often a client can will have access, especially in this sort of new modern world where Clients have access to their pay slips online, bank statements, all can be done through banks, rather than solicitors sending out requests to banks. The client has their bank statements at their the tip of their fingers, and they can get it over to us. And it allows us to then start working out things like loss of earnings, especially if you've not been able to work because of your accident, at a much earlier stage. It just really expedites the process.
Okay, thank you, Jack. You actually, so Daniel spoke a little bit earlier about the position with regards to admitting liability in full or in part from an insurance company perspective. Can you expand a bit about that, on that point with regards to when medical experts are brought in, for example?
Yeah, well, if liability is admitted, whether it's in full or in part, that's when we instruct our medical experts to examine the client. This is the second part of the burden of proof, where the claimant obtains medical evidence from their independent medical experts, who we instruct as solicitors, and that supports their injuries. So it puts their injuries into perspective. It lays it out into a report, which we can rely upon, which the defendant can see, and if needs be, the court can rely upon at a later date. We'd instruct the medical expert to examine the client. Now, this is a medical assessment, but it's not a conventional medical assessment. It's not like going to your NHS consultant or to A&E to sort of see what sort of treatment you need. They're looking at what injuries you've suffered. They're looking at what has happened, what injuries you've suffered, and then they're commenting on causation, the likelihood that your injuries that you're suffering and complaining of have been caused by the accident that has happened. And so we always obtain the claimant's medical records, such as their GP, hospital, ambulance records. This all goes to the expert to allow them to paint that picture of your injury. It's important that the independent medical expert has access to these records so that they have a full understanding of your pre-accident medical history and what has happened since the accident. It's important also that the expert's report will consider those injuries and confirm the causation. That's the most important part of the report, because that's what allows us to move us forward to the next steps and say, okay, the negligence of your insured, i.e. the defendant, has caused this accident and has caused these injuries. It sets everything out quite neatly into a package which we can then use to value your claim and to proceed to settlement if there's no issues with liability.
Okay, Faith, I'd like to bring you in now, because you've got a unique vantage point as an international student. But first I wanted to ask, from your perspective as a student, the subject of accidents at work, is that an area that you find particularly interesting? And are a lot of the issues that are being brought up in this conversation and part one of relevance to your studies?
Yes, I believe it is. I think that accidents at work is also just a very interesting subject to learn from a student perspective, but also to just hear how things work on a day-to-day basis is also very interesting. We learn things in class, and we learn how the court proceeding works, and we learn how people take these situations to court. But it's really interesting to sit and listen to this as well, because as students, we have a sort of disconnect from the actual hands-on approach of things. But I believe that accidents at work and all of these personal injury claims are a very important thing for us to learn, because it requires a lot of empathy, and it requires a lot of that skill set that we don't really see being explored even in our lectures. But I believe that even with my studies, I think it's been a really interesting and informative set of learning that we've been given, and I think that it's been really worthwhile to listen in on.
Great. And before we go back to accidents at work, a question for you, Faith, about the law clinic itself. How valuable is it for you to be under the tutelage of someone like Daniel Denton, for example, to learn about the process and to get involved in those real-world cases?
I would say it's incredibly valuable. As I mentioned before, we don't get a lot of hands-on experience. It's mostly workshops, and we have lectures, and we're doing a lot of writing, a lot of seminars, things where we're sitting down at our desk and we're not really hearing from other people or hearing perspectives. So having this law clinic and having the ability to be able to hear and to understand from a different point of view and to remove ourselves from the desk and to actually have some more insight, more of an insider perspective of what's actually going on in these legal spaces and how you actually talk to clients, how you navigate them through situations, how you're able to comfort them even when they're in a very difficult and critical time in their lives. It's been really, really effective because you don't actually get to know that. Like a lot of times we're looking at the legal aspect, we're looking at the points of law, the case law, and we don't know how to actually interact or speak to clients and how to actually bring them out of their shell and make them feel comfortable. So I think that's been a really good perspective to learn.
Well, thank you very much, Faith. That's really insightful. And you've got a few questions which I'm going to turn to you later towards the end of the conversation that you submitted. But let's get back to Daniel. So my next question to you, Daniel, is what if the claimant in an accident to work claim has sustained out-of-pocket expenses because of the injuries? Can you get those back from the defendant?
Yes, you definitely can. And what I should first of all say is not just any losses that the claimant's incurred today, but it's also future losses as well. So sometimes if, for example, our medical expert has forecasted a client will require further medical treatment in the future, we could also claim those back on a private basis from the insurance company as well. But there's all different types of out-of-pocket expenses that can be incurred. So that can range from travelling to some private medical appointments, paying for those private medical appointments and getting the money back for those. One of the main largest parts of a personal injury claim is the loss of earnings claim, and in particular the future loss of earnings claim. So those details are often very key and is often the largest head of loss in any personal injury case. We have prescription charges, damages to clothing, property or personal possessions, and also we would also ask the client if they've received any treatment through a private medical insurance policy that they have for someone, let's say, as Bupa or AXA insurance, because we would then have to approach the company to see if they wish us to claim back their expenses as part of the claim. It's known as a subrogated claim. So very often when we make the personal injury claim, we would approach them. So yes, there's lots of different types of expenses we can claim back. Another one that most people don't realise you can claim back is for care and assistance. Mm-hmm. So when you do a personal injury case, the first thing you need to think of is that the purpose of the claim is to put the client back in the financial position they would have been in if the accident had not occurred in the first place. So if as a result of the accident due to the client's injuries they require a family member or a friend to come round and help them with their personal care or household chores, we can claim that back on an hourly rate, and that head of loss is then held on trust for the person who's helped them out.
Sure, thank you so much, Daniel.
I mean, a lot of people say that doc review is a lot of what we do as lawyers, but documents are so important. Receipts, documents, information, invoices, all these things that we need the clients to be sort of compiling, sort of a dossier at the end of their claim when it gets to that stage, which we can go back to and fall upon to say this is all the evidence that we have. Because all that evidence for these sort of expenses that we can claim back needs to be shown to the defendant to allow us to claim it back. It makes it so much easier to argue that we can claim it if we have those receipts for it.
Okay, thank you, Jack. So we've been speaking about accidents at work. We've been speaking about how to bring a claim, sort of elements that a claimant needs to understand in terms of the evidence and the proof they need to provide, as well as understanding the position from a defendant and insurance related standpoint. But now let's turn towards settling a claim and the court process. So Daniel, can you speak a bit more about how the settlement of a claim process works from a claimant perspective?
Yeah, sure. So the first thing to note is that the compensation amounts will be made up of two elements. The first is what we call general damages, which is effectively a lump sum for the pain, suffering and the inability for the client to perform hobbies or interests. And we assess that by looking at the independent medical reports that we've obtained for the client. The second part of the claim is then called special damages, and those are financial losses that can be specifically calculated. So they would be the out-of-pocket expenses, the care and assistance claim. And what we do is we add up both of those figures. We prepare a schedule setting out all of these different figures so that the other party can see how we valued the claim. And then we wait for an offer to take place. Now, there's various ways we can try and settle a claim. So first is just by way of negotiation and open correspondence. So we can exchange offers with each other, so myself and the defendant's representative. If the claim is more complex, then we can suggest what's called a joint settlement meeting. Now, what that would involve is that both parties and legal representatives would meet at a particular location. The claimant's representatives and the claimant would sit in one room, the defendant's representatives and defendant would sit in a second room, and then in the third room there'll be like a negotiating room for the legal representatives of both parties. And the idea of the joint settlement meeting is to see if you can either flash out a settlement on the day, and the client would hopefully be present as well on the day at the meeting, or alternatively try and narrow the issues between the parties. Now, one other way which the court actively encourage now is through mediation. So we could instruct a mediator who would effectively be trying to mediate between both parties, particularly if there's been a lot of tension between the parties. And that's quite an effective way of trying to settle a claim.
Only 1% of personal injury claims ever actually make it to court. And that's a good thing for clients. It's a good thing for the litigation in general, because it stops the client having to be put through quite a harrowing and stressful court process, which can take years. It is in the interest, the benefits of all parties concerned, to settle the case out of court. And that's not to say that we won't use the instruments of the court if we need to, if it's necessary. We won't just sort of settle a claim because it's easier to settle it out of court. We'll make that judgment as the case goes along. But clients should come into this process not fearing court, fearing that it might be an ever-present aspect of the claim. What's more important is getting rehabilitation for the client and negotiating a settlement with the insurers for the defendant outside of court, leaving court as a last resort.
Okay. So, Faith, you had a few questions about that court process. I think you've got two questions, which we'll put towards Jack, since Jack was just last speaking. So, Faith, would you like to go ahead and...
Yes. So you mentioned that the process of sort of negotiating the settlement and mediation, and that reaches towards the end of the case. But I wanted to ask, if these two parties are unable to reach sort of settlement and they have to go and commence through court proceedings, how exactly does the court deal with situations like that and accident at work claims? How do they navigate that?
Yeah, so the court is at every stage trying to ensure that the parties are coming to an agreement, as Dan said. And when you get to a personal injury claim, you've sort of expended all options. You can't come to an agreement with the other side. The first thing to note is that there is a 3-year limitation for personal injury claims. And what that means is that any case, if it's still going on, needs to be issued at the court within 3 years of the accident date. Now, there are a couple of caveats to that and a couple of special circumstances, but that is the general rule. And if you do get to that stage, we as solicitors will not be waiting until the last day to issue your claim. We will have a good amount of time in advance if we consider that this is very likely going to be issued. And so we'll do that maybe 6 months in advance of the limitation date. And we'll get to that stage and we will we start putting together loads and loads of court documents. It's something called a Part 7 claim or a Part 8 claim, depending on what you're looking for from the court. And these are court forms which get issued by solicitors to the court to notify the court that we're issuing proceedings against the other side. Now, there are a couple of deadlines then which get kicked in for the other side. We need to then serve evidence on the defendant, things like medical reports, all that information to allow the defendant to have a claim to answer, to formulate a claim to answer, and to formulate a defence. There are lots of sort of litigation documents which then suddenly come into play, lots of deadlines, things like directions questionnaires which allow us to start getting, thrashing out the issues, talking about more parts of the claim, and to make things clear for the courts so they understand what type of claim is coming their way. If it does come before a judge, which will be at a trial, so a trial judge will look at it, they're trying to figure out, well, if this comes our way and this has to go to court, it has to go for a trial, what issues are we going to be looking at? So, as I say, the court is, though, actively encouraging the two parties to come to an agreement. So even if the solicitors do say to you, okay, we've got to a stage where we can't come to an agreement, we're going to have to issue court proceedings, don't think that means that your case is going to have to go before a judge and it will be the judge that decides it. Even once the case has been settled, it has been issued, we can keep negotiating, keep doing things like trying to set up a JSM, joint settlement meeting, mediation. All these things can happen. There's often cost management meetings as well, which happen, conferences which happen, all as part of the court process, which the client doesn't need to be a part of. But it's just getting information ready for the court so they know what's going on, and encouraging settlements at every single stage, leaving that opportunity, leaving that door open effectively if it's needed.
And there was another question for you, wasn't there, Faith?
Yes, thank you for that answer, Jack. But in terms of more complicated claims, where the claim value is much higher, how do courts navigate those cases?
It's not as different as you would think. When it comes to claims that are, the way that claims are valued in personal injury is that you have small claims, which are anything, especially in personal injury, and it's not specific to accidents of work, but for personal injury, you have small claims, which is anything below £1,500. Then you have fast track claims, which are claims between £1,500 and £25,000. There's a new track which has been introduced recently for cases that are brought after the 1st of October 2023, which is something called the intermediary track. Again, that's just it's just a means of grouping together the types of injury claims for the court so they know how to process them. That's between £25,000 and £100,000. And then you have the multi-track, which are those sort of catastrophic injury, high-value claims, which is just upwards of £100,000. Those are all types of claims that we as your solicitors will be constantly valuing and assessing as we go into it. In terms of issuing, it's no different. It all gets issued the same way. It just depends where it goes. So a more complex claim might be issued at the High Court as opposed to the Civil National Business Centre, which is where sort of lower value claims tend to be issued. And your solicitor will be advising you about this, and they'll know exactly where it needs to go because they know exactly what type of judge needs to be looking at it and making a decision on it. So you may have just a civil judge who's looking at it, a circuit judge, or you may have perhaps a master who is looking at it from the Royal Courts of Justice and the High Court. They're far more experienced to deal with these higher value claims. So when you do go for that issuing process, it's just trying to figure out what sort of bracket the claim falls into. But it's ultimately a very similar process for each claim.
Thanks, Jack, and thanks, Faith, for those questions. So we're winding down our conversation now about accidents at work, which is the topic of today. Daniel, I'm going to turn to you now. So if a case does start at court, it goes all the way to court, does it mean it will end up at a hearing before a judge?
Yeah, so as Jack previously mentioned, only 1% of cases actually go to a final court hearing. Mm-hmm. So throughout the case, both parties are going to be weighing up the risk of themselves losing, because there is still a bit of a lottery if you go to court whether the judge is going to prefer your evidence compared to the other party's evidence. So the role of the claimant representatives is to try and put enough risk onto the insurance company to encourage them to settle the claim. But the majority of the time we are able to reach a settlement, provided that both parties are prepared to take a sensible approach.
Okay. Now, members of the local community will be listening to this conversation, some of whom may have experienced an accident at work or know someone who is going through something that they've experienced. Daniel, what's your advice to someone who has been involved in an accident at work? What should they do?
Yeah, so I think the main take-home of today is to make sure that you seek legal advice as quickly as possible after the event. This will give you the best opportunity to win your case because it will help with the evidence gathering. Because as I mentioned at the very beginning of the talk today, the burden of proof is on the claimant to actually prove the claim. So getting the initial legal representative's advice is absolutely critical to the success of your claim. Mm-hmm. We will discuss all potential funding options with the client. So if in an accident at work the client is a member of a trade union, we would also encourage the client to speak to their trade union representative, and it may be that the case can be properly funded via the trade union rather than through a no-win, no-fee firm of solicitors. Another advantage of also seeking early legal advice is that we can hopefully also assist with the rehabilitation process that I discussed previously. So the quicker we notify the insurance company of the claim, mm-hmm. the quicker the insurance company will start to investigate the accident and turn their mind in relation to private rehabilitation treatment. Okay. Now, the reason being is that it's in the insurance company's interest to try and give the client the best opportunity to make a full recovery, because the better recovery the client makes, the less the claim's likely to be worth.
Great.
To add to Daniel's point about seeking legal advice as soon as possible, I think there is definitely an anxiety amongst the public and clients that as soon as you approach a lawyer, you will be charged lots and lots of money. In the personal injury world, that is very much not the case. For most firms, certainly, that consultations for getting advice are free at the first point. You know, going to a solicitor's firm for personal injury and saying, "I think I have a case. What do you think?" You're not going to be charged for that, because we want to try and ascertain whether you've got a claim in the first place. What I think is most important is that for the student clinic, you know that when you go to the students, go through the university, speak to people like Dan, is that they're doing it free of charge in the first instance for that advice. They're not there. They have your best interests at heart. Always do your research about the solicitors' firms that you go to, and if someone's trying to start charging you lots of money in the first instance, I'd say steer clear. Go to trusted local community centres like universities, like law centres, like legal clinics, which you know are part of the community and have your best interests at heart.
Great. And very briefly from all three of you, actually, could you tell our listeners, if they didn't join us at the start, how this law clinic can help members of the public? Daniel, you go first.
Yes, so one of the benefits that's not immediately obvious is often we come across clients who've already tried to start the process themselves and are then struggling to navigate themselves through the process. So the service can provide an opportunity to steer the client in the right direction, or equally as importantly, if we think the claim isn't likely to be successful, to advise the client that as well, because we don't want them to end up being in a situation where they're going to have to pay money to another party.
Okay, Jack?
If you'd like to learn more about the Bloomsbury Institute Law Clinic, then please do visit their website and look up Bloomsbury Law Clinic. Sarah has said as well, that potentially if you want to make an inquiry, get in touch. That's the most important thing. You get in touch with us and talk to us about it. The phone number for that is 03300 294 446, or indeed email on BILRADIO, so BILradio @hja.net.
Thank you. And Faith, from your perspective, whether it's a friend or a family member, perhaps that was in the UK at this time, and they're listening and they are wanting to know more about this personal injury law clinic, what would you say to them? How could it help them?
Yeah, I would say it's extremely helpful, especially with access to justice and access to just being able to be guided as well. A lot of people aren't very familiar with the legal scheme, and being in situations such as accidents at work can leave them very vulnerable, leave them very confused. And having this law clinic open for people to come in and be able to seek that guidance and push in the right direction, as was said earlier, is really special for them. It's not only is it increase our own understanding, but it also helps them navigate the claims that they want to take forth and what they want to continue to do. So I think that having that door open is really special for clients and for people all around the world to be able to have that access and know that there's someone always in their corner, and they don't have to go through insane loopholes to be able to seek justice and to have what they need. But, yeah.
Thank you so much, Faith. Daniel, let's let you have the final word. If someone's hearing this and wants to get in touch with you, what can they do?
Yes, I'd be delighted to to advise anybody who has got an issue in relation to a personal injury claim. Again, please contact 03300 294 446 or email bilradio@hja.net. Like I said, it is a free service, and hopefully you'll get some value out of the service. And yes, please feel free to contact us.
Great, and if you do want to know more about Daniel Denton, the work he's done in the past, the cases he's dealt with, a bit more background about his experience and the type of accident at work cases he's dealt with, even the recent ones, head over to www.hja.net and look up his profile under Daniel Denton, Denton. So that's goodbye for now, and we look forward to speaking with you on the next episode of The Letter of the Law and the London Legal Podcast. Thanks for listening.